Hello, good morning everybody. Welcome to another video. Today's date is Saturday the 11th of April 2026 and it's around 9:15 in the morning, and I'm making this video concerning this gentleman. He is a district judge for, I believe, Exeter and South Devon, and I have come across this judge, District Judge Charles Murray, on two occasions, the first being on the 5th of September 2024 and the second was on the 10th of February 2026. So for those of you who have followed my YouTube channel will know the story about my it's now 4-year battle with Sanctuary Housing, who have repeatedly failed to adhere to their legal responsibilities as per my tenancy agreement. So what I'm going to do is I've made videos on my other channel, which is now deleted, so many of you may have seen my struggles, my battles with my social housing landlord Sanctuary. But I'll give you a rough recap for those who are unaware. So here we have a copy. This is part of a bundle of evidence sent to me by the defendant's solicitor for the trial on the 10th of February this year. But this is the original tenancy agreement. As you can see, there's me, the address, the date the tenancy began, Monday the 12th of May 2008. So there we go. Now I've turned to section 2 of the tenancy agreement, and it says the association's obligations. The association agrees, then it goes on about what they have to do to give the tenant possession of the premises at the commencement of a tenancy, not to interrupt or interfere with the tenant's right peacefully to occupy premises, blah blah blah, just general stuff. But the important bit we're interested in is at the very bottom there. You can see number 6. So number 5 there, to take reasonable care to keep the common entrance, halls, stairways, lift, passageway, rubber chutes, and any other common parts, including the electric lighting, in reasonable repair and fit for use by the tenant and other occupiers of and visitors to the premises. This is the bit. To redecorate in accordance with the maintenance program and to keep the exterior of the premises and any common parts in a good state of decoration. So I read back number 6 again. To redecorate in accordance with the maintenance program and to keep the exterior of the premises and any common parts in a good state of decoration. Now, nobody seems to know the maintenance program. I've asked for it on numerous occasions, as did an independent surveyor asked for a copy of the maintenance program, and still waiting. So I question whether it even exists. So that is quite clear. To keep the common parts in a good state of decoration. So we've seen what the tenancy agreement says and what the landlord, Sanctuary Housing, is obliged to do. I must say at this point that in addition to rent, the weekly rent, all the tenants of all the properties, the 30 flats here at Charlton House, and every single one of them is subject to a weekly service charge. Mine is around £12, I believe, but it's due to go up in July. So The service charge is we have like a communal window cleaner who comes once a month. We have been a large area. There's a little bit of grass and trees, and they generally, periodically, I'm not sure what the time scale is, but they will keep it neat and tidy, trim bushes, etc. But not all, just some. So what happened was, since 2022, I kept moaning and groaning to Sanctuary that the place looked like a shithole. The paint was peeling off the walls, flaking off the walls. There were holes in the walls. There was black mold, green algae, all sorts on the walls. It looked like a dump, and it was indeed a dump. So, despite many assurances, promises from Sanctuary, from the housing officer, Emma Bowden, and the person before her, nothing ever happened. That's why I commenced my court action on the 31st of July 2023. So things went on, and there was a solicitor, Mohammed Yasser, lovely guy, lovely gentleman, never met him of course, but he worked for Sanctuary, the legal department, and we got on well, me and him. So he said he would obviously investigate my complaint, the area subject to my complaint. He asked on 2 separate occasions for me to give permission to delay Sanctuary providing their response, so their evidence for my claim. And that resulted in, I believe it was the end of October, a surveyor, a Mr. David Shawland, and Emma Bowden, along with myself, meeting at Charlton House and going through the areas subject to my complaint. Unfortunately, nothing happened. Hence, the first court case that was held on the 10th of January, and that was the 10th of May. That was in 2024. And the reason for that first court case was that I had, because Sanctuary's their contracted surveyor, a Matthew Lake, working for a company called Waitman's, I don't know what happened. I'm not going to comment. I've done that before about Mr. Lake, but he I think there's over 70 emails, text messages, phone calls that went unanswered. He just ignored me. Never responded to anything. So he never even responded to court documents, and that resulted in the courts, the Civil National Business Centre, awarding me a default judgment for the value of my claim, which was £10,000. So naturally, once that happened, then they started listening, and they appealed, and that was a hearing on the 10th of May in 2024. Now at that hearing, the Judge Eaton Hart was the gentleman, the judge, a nice guy. He seemed a nice guy, and he set aside the argument. Sanctuary was saying that they never received documents, they didn't know this and they didn't know that, which, to be honest, was complete and utter tosh. One example I'll give that. Directions questionnaire, a document that has to be signed by both parties, 2 separate documents. One is sent to the court and one is sent to each other. So I'll send the directions questionnaire to the court and a copy to Sanctuary. Likewise, Sanctuary will send a copy to the court and a copy to me. I did mine on time, they didn't. So they just I don't know what the motive was, up until I got the county court judgment of £10,000 default judgment. They just didn't respond to anything. The defence which had been filed was struck out prior to me getting the judgment. So me and Mr. Mohammed Yasser were getting on along well, and I put in an offer, and he rejected my offer but put in a counter offer, and I then sent an email. I believe it was the 3rd or the 4th of November 2024, in which I wanted to accept his offer, because this wasn't about money, which I'll go on this document here. You can see here. I'll talk about in a minute with Tom in order, but this wasn't about money. So what happened was, when I sent the email, I got an automated response. Mohammed Yasser no longer works for Sanctuary Housing, or words to that effect. That was it. And then a couple of days later, I had an email from this Matthew Lake character from Waitman's. A totally, in my opinion, nasty man. So, moving forward, again, largely ignored for most of the time, until I got the court judgment. Then, at the hearing on the 10th of May 2024, we had the hearing where the default judgment was overturned, and then on the 31st of May we had a second court appointment. This is in 2024. The 31st of May was a directions hearing, so the judge ordered certain things to happen. One of those things were Sanctuary Matthew Lake was trying to get a surveyor. So Sanctuary would provide their surveyor at a cost to nothing to them, and he would make his report, and he wanted me to get my own surveyor at a cost of hundreds of pounds in order to have it surveyed, and the two surveyors to meet and survey at the same time, which is totally out of order. And it was quite clear early on what Matthew Lake's tactics were, that I'll soon get bored and fed up and I'll give up. It'll become, because I was a litigating person, I'll, can't afford the thousands of pounds of legal costs it would have taken hiring a barrister or solicitor. So I could see what Mr. Lake's game was, and the judge agreed that a joint surveyor with a maximum fee of £750 would be appointed, and we would split the cost, £375 each. So the surveyor we chose was a lovely guy called John Collison. Mr. Collison came on the 5th of July, I remember. It was pouring down the rain. It was late. Around 5 p.m. It was, dark. Although it was summer, it was July. It was too dark. As I said, it was chucking down the rain. It was an awful day. And so he did his job. I showed him the issues, and he released his reports, I think it was maybe 18th or 19th of July, and his report 100% vindicated my complaint. In other words, he agreed with my complaint. So therefore, I had been successful. My claim had been successful. So, going back to the judge, Judge Eaton Hart, in his directions hearing, the final part of that hearing was that a court date would be made, the first date available in September 2025. So sometime in September 2025 was going to be a court date. So as time got nearer, Matthew Lake and I was, obviously he was now talking to me now, because obviously I won my case and it was just how much it was going to cost Sanctuary Housing. So I agreed. I put in several offers. I must have had at least half a dozen offers of settlement rejected. Or I won't say rejected, not responded to, just didn't respond to it. Which just shows the type of character Matthew Lake is. But so this is the Tomlin order. So I signed this Tomlin order on the 10th of August 2024, and the as you can see underneath, Waitman's signed it on the 9th. So this was what the Tomlin order said. The defendant shall pay the claimant the sum of £401, then, figure in words, the settlement sum in full, and final just get back more clear. Settlement of the claimant's claims relating to the occupation of Flat 5 Charlton House, Dawlish, EX70BS. So £401 is a strange figure. My offer of settlement was £1 in damages. Yes, £1 in damages. The £400 was for my expenses, legal expenses and other, the evidence gathering, the photographs I had to take. Obviously, every time you take a photograph, you have to have it, top quality. I believe hundreds of photographs were taken, and they're in colour. I was paying 80p per photograph, so 100, that's £80, and you've got to keep one for yourself, send one to the court, and send one to the defendant. So it was a very expensive. That's all I was asking for. Then it says the defendant shall clear the arrears of rent owed to the defendant by the claimant in respect of the claimant's, just go closer, occupation of a property as exists at the 8th of August 2024, being the date of which a settlement of a claim was reached. So that's very important. So they'll clear all the. So part of my offer settlement was to clear my rent arrears, leaving a zero balance. So, and that was to be done on the 8th of August 2024. And the last part here, for the avoidance of any doubt, the claimant is not responsible for any of Mr. Collison's fees incurred in relation to his inspection of a property on the 5th of July 2024, or the preparation of a report dated the 18th of July 2024. So basically, the £375 I was not liable for as part of this agreement. Sanctuary would pay the whole lot instead of half. So on the next page we have the number 4 of the Tomlin order. The defendant will replace the missing door lock serving flats 1 to 16 Charlton House, Dawlish, and renew the decorations on the communal walls, or to the communal walls at Charlton House, in accordance with the expert witness, that's the John Collison's report. There we go. Mr. John Collison, dated 18th of July, within a reasonable period of time. So there again, important there. The 2 points there are a reasonable amount of time to do the work and to write off any rent arrears as of the 8th of August 2025. Oh, sorry, 2024. Sorry, 2024. So when we turn to this document, this is a rent service charges for my flat. So there we are, you can see the service charge, £11.18, and it goes through each payment made. You know, my rent was £97.57 a week here. This is the rent statement. So I'll turn over the page to get to the part we're interested in. So remember that Tomlin order? Reducing the arrears of my account, which the date was the 8th of August 2024, and reducing whatever the arrears were to a zero balance. So here we go. So as you can see, the third transaction down, you see your universal credit. So £18.20 of universal credit was paid. I don't know why it's got universal credit, because I actually wasn't on universal credit. I was on another benefit because I was sick. I'd had an operation and was off work, and so I was claiming sickness benefits, not universal credit. Now, if you look at this, the 8th of August, so £18.20 was credited, and the balance on the account was £741.65. So after this £18.20 was paid, I owed Sanctuary £741.65. Now the reason I owed that was I had refused to pay my rent, basically, as a protest. I know some people will find that dangerous, but I'm aware of the 8-week rule, which I believe it's Section 8 of the Housing Act states that a landlord can only evict you if you're for rent arrears if you're 8 weeks or more in arrears on the date they apply to the court, and also on the day of the court hearing. If you were 8 weeks or more in arrears, then the judge would have to grant an eviction order against you. So I was aware of that, and obviously at this stage I had the money, so if that was coming I would just simply pay off arrears. So it's quite clear, £741.65 a balance on the 8th of August 2024. As part of that Tomlin order, that had to be cleared. And as you can see here, on the 19th of August 2024, you can see it says compensation, £741.65p. So they paid in full every single penny of the rent arrears. There we are, 741, the third one down, and there, 741.65, and then in balance and credit 741.65. But, and there is a but, housing benefits, I don't know, I don't think housing benefits exists anymore. I'm not sure. I think it's part of universal credit. I'm not sure how it works now, but I know Teignmouth District Council were my local council. They were paying my housing benefit, and I was getting housing benefit, and obviously housing benefit is paid for weekly in arrears. Okay, so on here it's got a credit. If you look, it's the second from the bottom, so one above compensation. The 13th of August, housing benefit, £418.40. Now, my argument was, and I don't know why, but I spoke to several people, solicitors and others, the Citizens Rights Bureau and other organisations, and they all agree with me. But the judge couldn't see it, and neither could anyone else, neither could Sanctuary. but it's quite clear. The £418, 40p, that equates to housing benefit. I believe it's paid up to the 10th of August, I would say, around about the 10th, the 11th of August. The rent week works from Sunday to Saturday. Sorry, from Monday to Sunday. From Monday to Sunday, sorry. That's the rent week. Monday to Sunday. So, as you can see, this payment of £418.40, it's put my account, and this is one thing I didn't notice, but as you can see, as of the 19th of August, because of this payment, the conversation we took off, can you see it says minus £313.80. Now I didn't pick this up. All I knew was I was in credit. And so I asked Sanctuary, I said, look, you're not entitled to this money. I want it back. It's not yours. Indeed, it's not my money. It belongs to the council, the housing benefit. It's an overpayment. They refused. They said no. So what I did was, I then wrote, because by this time I'd signed and sent off my copy of the Tomlin order. So I emailed the court, it was the Torquay and Newton Abbot County Court, requesting that I can withdraw because Sanctuary Housing had already broken this order. They had not written off the money completely because this £313.80 was for most of July and the beginning of August. But there was no debt because it had been written off. Put it another way. You have the £418 put into your account, which is for something you've already got, because you've already got that 418. So a company owes you £418. Or let's say eBay. I'll use eBay as probably the best example. So you sell something on eBay, and eBay send you the money into your bank, £418.40. They've done that. So let's say they've done that by writing off the debt. Okay? Therefore, you get it a second time because of this housing benefit. So twice. Leaving a plus because it was actually the judge. I'll tell you, I'll explain about that in a minute. I don't want to go too forward of myself here. But going back to the Tomlin order, I believe they have broken the agreement of the payments, and it's the evidence is there, so you can decide whether I was right or wrong. So going back to the infamous Tomlin order, you remember I showed you, remember that it's very important, about the final part, number 4, about the surveyor's report, and this is what the Tomlin order says. The defendant will replace the missing door lock serving flats 1 to 16, Charlton House Dawlish EX70BS, and renew the decorations to the communal walls of Charlton House Dawlish EX70BS in accordance with the expert witness report of Mr. John Collison, dated the 18th of July 2024, within a reasonable amount of time. They did not. They did not do this. Nothing was done. So therefore, that is 2 out of 4 of the particulars of the Tomlin order have been breached, have been broken by Sanctuary Housing. So What happened next then is we returned to the Judge Murray. A hearing date was set for the 5th of September 2024. So, and Judge Murray was the presiding judge. He heard my arguments, the reasons why I wanted to withdraw the Tomlin order, because it had already been breached within days, as I've just shown, and he disagreed. And I was astonished, how could you disagree with that? Obviously, number 4, which I've just shown you, which talked about the work being carried out in a reasonable amount of time. Again, it was only, a month roughly, since the Tomlin order. So, yeah, I agree that's not a reasonable amount of time. To me, a reasonable amount of time would have been by the end of the year. So don't forget August. So giving them, August, so most of August, September, October, November, December. So giving them the best part of 5 months. We'll say 20 weeks. 20 weeks, we'll say, just for argument's sake. Giving them the best part of 20 weeks, which, is, I believe, is a reasonable amount of time. I believe that's being generous. So this Judge Murray, he didn't believe, he didn't get it about the money, about the rent overpayment by the council. Incidentally, I repaid the council out of my own pocket the overpayment. So, and then again, and what I did again was, because I had that surplus, if you remember, was it £313 surplus on my rent account? £313.80, I believe it was. Because obviously I was 741 in arrears, now I'm £313 in credit. So I told the council, had a meeting with the council at the HQ of Teaminge Council, and I explained to them, and I asked that this overpayment, the next payments they send to Sanctuary to deduct this money. And they agreed, and that's what we did. So they got their money back. No way was I going to let Sanctuary get away with, taking £313 of taxpayers' money. So, but Judge Murray couldn't see that. Richard Dewsbury, obviously the barrister for Sanctuary, couldn't see that. So, Mr. Murray, Judge Murray, made an order, I think it's N24 General Form of Order or Judgment. And his order was that the Tomlin order hadn't been broken, but, and this is where it gets bizarre, in addition to a Tomlin order not being broken, he made a new order dated the 5th of September 2024. And I can remember as clear as day, I remember saying to the judge, just before the end of the case, the hearing, saying to him, does that mean that the Tomlin order is now null and void, and your order obviously replaces the Tomlin order? And he said yes. He said yes. This District Judge Murray, that's what he said, yes. So here I have, as you can see, in the County Court at Torquay and Abbott, dated the 6th of September 2024, the general form of judgment or order. So this is what replaces the Tomlin order. And this is what it says. Before District Judge Murray, sitting at the County Court at Torquay and Abbott, Nicholson Road, Torquay, Upon hearing the claimant in person and counsel for defendant, and upon the court determining that the parties reached a compromise agreement on or around the 8th of August 2024, in the terms set out in the schedule to a draft Tomlin order signed by the defendant on the 9th of August 2024, and with the claimant on the 10th of August, it is adjudged that the defendant complied with paragraph 2 to the schedule of the said Tomlin order by crediting the claimant's rent account with £741.65 on the 19th of August 2024. Well, that is technically right, he did. But what he did not take into consideration, my argument was, the payment of £300 odd by the council. It had been written off. And how can you pay a debt that's been written off? That's what happened. And I can remember saying to the judge, I should say, does that mean this place to an order? He said yes. So, and he even had the cheek to, the claimant, me, shall pay a contribution towards the defendant's costs pursuant to the assessed at £100. So therefore, I was told I had to pay £100 towards the defendant's court costs. Absolutely outrageous, absolutely bizarre. But that's how it was. So I mean, I don't know what the judge, I believe the judge didn't listen to me, and I think a combination of several factors, perhaps my being a litigating person up against a barrister, was obviously that may have been a factor. But to me, the facts are plain and simple. And yet, a county court judge, Judge Murray, decided otherwise, which, was not right. But anyway, so don't forget, he's made it, so this order now replaces the Tomlin order. And that was on the 6th of the 5th of, well, it's dated here the 6th. The actual hearing was on the 5th of, I don't got a date here. Yeah, there you go. Dated the 5th of September 2024. So his order was on the 5th of September 2024. So, moving on from the debacle of the 5th of September, and Judge Murray's, in my opinion, outrageous order, to rub salt wounds, I had to pay £100, and towards I believe the costs were in excess of £5,000. Of course, the sanctuary didn't do nothing, did absolutely nothing. And so what I did was, I complained to the court and asked the court for another hearing. So here we have a notice of hearing of application in the court. This is dated the 19th of May 2025. And this is what it says. The hearing of a defendant's application for settlement agreement not being complied with, obviously, like I say, the works have not been carried out. This is dated the 19th of May. Don't forget September, the order. September. Judge Murray's 5th of September. Judge Murray ordered a reasonable amount of time. So from September to the 19th of May, nothing. So not being complied with. A hearing will take place at 10:15 a.m. on the 29th of May 2025 at the County Court at Torquay, Newton Abbot, Nicholson Road, Torquay, Devon. So there we go. So that was a new trial date set because Sanctuary Housing had ignored the judge. So For argument's sake then, going back to the order, Judge Murray, the 5th of September, said Sanctuary hadn't broken the order. Well, now they clearly have, because a reasonable amount of time, September up until May. I mean, the only thing about this is, obviously, during that time, I would be contacting Matthew Lake, the solicitor acting on behalf of Sanctuary, and when's this work going to be carried out? If you don't, I'm going to have to go back to court, because it's a court order. It's court ordered, and yet I got no response. Absolutely nothing. So my last course of action was to go back to court, which I did. Now, I didn't actually attend the court on this day because there was no hearing on this particular day. What happened was I'd already pre-booked a 10-day holiday to Brighton in Sussex, and so I was unavailable. So I wrote to the court explaining the situation, showed them obviously copy of my train ticket, copy of a booking form, etc., proving I was away on holiday at this date, asking for a new date to be set. And indeed, a new date was set. So next we have another general form of judgment or order. So this was the result of the next court hearing. You can see it dated here the 1st of July 2025. Don't forget the 5th of September 2024. So we're 10 months post the court order being made. This is what it says. Before Deputy District Judge Baptist, sitting at the County Court at Torquay and Newton Abbots, Nicholson Road, Torquay, Devon. Upon hearing from Miss Wills in person and Mr. Dewsbury of counsel for the defendant, and upon the court having considered the schedule of a Tomlin order agreed between the parties on the 9th and 10th of August 2025, and as referred to in the order of District Judge Murray, and dated the 5th of September 2024, and upon the scheduled Tomlin order having stated that there would be decorations to the communal walls of Charlton House, in accordance with the expert witness report of Mr. John Collison, and upon the report of Mr. Collison not having excluded any part of the communal walls, Sanctuary Housing will redecorate all of the communal walls of Charlton House, Dawlish, EX7 0BS, and for the walls which have not been redecorated since the making of the order on the 5th of September 2024. Those parts of the wall shall be redecorated by no later than the 13th of October 2025, dated the 23rd of June. There we go. So, 23rd of June 2025. Now, at this hearing, obviously I'm pissed, Sanctuary are just taking the piss out of me, and they're taking the piss out of the court. This hearing lasted about barely 5 minutes. I showed the photographs, the evidence, the camera doesn't lie, and the judge agreed with me. And the judge did say, the few words he actually spoke was, addressing Mr. Dewsbury, the counsel for the defence for Sanctuary. He did say that, on looking at the pictures, basically, but there's no excuse, I can see the trees blocking walls, and yet it says there, all parts have to be redecorated, and yet half the walls were left untouched. A lot of work was done, but half the walls, were left untouched. So they had to be done. And she had given a date, she set a date by no later than the 13th of October 2025. So because the works had yet again not been completed, most of it was, but not all of it, Sanctuary ignoring my repeated requests they do it, we went to court yet again. and this time it was with District Judge Murray. And so this is the, as you can see, general form of judgment or order, dated the 25th of February 2026. The actual hearing date you can see here was the 10th of February, and that's important to remember. And it says here, before District Judge Murray, sitting at the County Court at Torquay in Newton Abbot, Nicholson Road, Torquay, Devon. Upon hearing the claimants in person and counsel defendant, upon the claimant's application, it is ordered that the application is dismissed. The claimant shall pay the defendant's costs of the application summarily assessed at £2,494, dated the 10th of February 2026. So my case was dismissed by Judge Murray, by this man. Now, the case lasted for around an hour and a half, and I said my piece, and again, I don't know what. It's very difficult to explain the reasoning behind Judge Murray and his decisions, because this was completely outrageous. Sanctuary have repeatedly, and there are still, today is, I said at the start, it's Saturday the 11th of April 2026, there are still areas of the wall, of the communal areas, which were ordered by Judge Baptiste to be completed by the 13th of October 2025, that are still yet to be touched. And yet, I won my case and it was dismissed. And to add insult to injury, I'm shafted with a bill of £2,494 in costs. Now, I obviously, when I realised I was losing, even though I won, I told the judge in his summing up that this was outrageous, this was scandalous. He asked me to be quiet. I said, no, I've been quiet for too long and I'm going to say what I have to say. I said, this is a scandal, this is outrageous. Your decision is absolute nonsense, is what I said. The judge then asked me to leave the court, which I did. So I was not there for the last 2 minutes, however long it lasted, or I was asked to leave and I left the court, accompanied by a security guard. So I did say that I will be appealing his decision, because it was absolutely outrageous. I don't know where his reasoning is. I showed evidence, I showed photos of the work not being completed, and a lot of it is to do with a previous video I made on sanctuary housing, where I go through a letter I received, dated 1st of April, from a Scott Vile area manager at Sanctuary, in which I criticise Emma Bowden, the housing officer, for her continuous lying, her blatant lying, and I believe it's, well, I just don't know. Like I say, it's truly shocking. Sanctuary is shocking, and this judge, if this is UK justice, it stinks, So I get kicked out of court. I say I'm going to appeal, but there's a problem, which I'm going to show you. I'm going to go back to the general form of order of judgment. So this again is the judgment. Look at the date, the 25th of February 2026, stamped by the court. So this document I never received. I'm still waiting for it on Saturday the 11th of April 2026. I'm still waiting for this letter. Is it called, I'm not sure what the number of the letter is. They all are different numbers. But this general form of order of judgment, I'm still waiting for my copy to be sent from the court. This copy I have was actually emailed to me by Matthew Lake, the defendant's solicitors. He emailed me this copy. I never received it from the court. But the court rules say you can appeal any decision you don't agree with, but the strict guidelines are you have 14 days from the date of the hearing. Now I have two questions here. The dates of the hearing, the 10th of February 2026, so 14 days would be the 24th of February 2026. Number one, how the hell can I appeal this outrageous decision when this letter is dated the 25th of February, so a day after the 14-day period had expired? Obviously, had I received it, don't forget I've not received this letter, this judgment or order form. I've not received this, never have done. I would have been out of time. So it's absolutely outrageous. So therefore, what I'm going to do moving forward is, it's not over. There are sort of certain grounds you can appeal, one being new evidence being submitted. I now have evidence, which I've shown in the previous video, of a meeting that took place, although the dates are disputed, in July of 2024, in which Emma Bowden, the housing officer, and a surveyor came, and Emma Bowden denied that meeting ever taking place, ever meeting me, and yet all sorts of crap was alleged which didn't happen, has been mentioned in that letter, which I say covered in a previous video. So yeah, I'm sort of slowly gathering evidence. I have witness from the tenant of flat 18, and yeah, at some point in the next few weeks I will be attempting to launch an appeal on the grounds of new evidence. And as I say, turning back to this gentleman, I think, in my opinion, and it's only my opinion, in my dealings with him, he is biased, in my opinion. Judge Murray is biased. He's also doesn't listen, because he clearly didn't listen. And I got to question, when everyone I've spoken to outside the sanctuary of Judge Murray has agreed that sanctuary had broken the Tomlin order, and yet with Judge Baptiste in 2025, I asked her that there has to be some punishment for sanctuary for breaking a court order repeatedly, breaking Judge Murray's order on the 5th of September, so breaking his order, and yet Judge Baptiste said to me, I'm not going to go into costs, she said. I have a stack full of files by my chair to go through. That was her excuse. So sanctuary, yes, it's cost them thousands of pounds in court costs, but they have escaped without any sanction from the court whatsoever. Not one single sanction is put on sanctuary. Judge Baptiste confirmed they broke the court order of Judge Murray. They broke the Tomlin order. She confirmed that. And yet the common order is still today, because the work still hasn't been carried out. So they still haven't been carried out. So over a year, the 5th of September 2024, we're now in April 2025. That's what, 18 months later, we're no nearer fulfilling the obligations of the court order, or, if they want to be stubborn, the non-existent Tomlin order. So, it's, I believe this Judge Murray, I don't know the reasons why. I have a lot of thoughts I would like to say, but I don't want to get into trouble, because obviously this is going on to YouTube. So I'll have to, I'm very angry, I'm frustrated. All this 4-year battle has come to an end because the case has been dismissed. And yet, I haven't been given any chance to appeal. I haven't received nothing from the court from this case in February this year. And it stinks, absolutely stinks. Stinks of corruption, I guess. So, yeah, that's my story about my case for conclusion, or alleged conclusions, that I plan to fight on and explore every avenue I can. I haven't been given the opportunity by the court. They've not sent me documents. Interestingly, I must mention that the court hearing, apparently Matthew Lake at Sanctuary says that he did not receive a copy of that court date for February this year, and so I had to take a photo of the letter I received of the date of the hearing in February before this judge, and send it via email, a photo of the court date. And Matthew Lake informed me that he had to email the court requesting those send document. So that shows you one thing, that the Torquay and Nunavut County Court is incompetent. This is serious stuff. When you talk about thousands of pounds, and when documents aren't sent when they should be, then there's something seriously wrong with the whole system. So I thank you everyone ever so much for watching this latest video in my saga, and let me know, but especially if by coincidence anyone's come across this judge before, Judge Charles Murray, and it'd be interesting to know what you think, good or bad, if you've come across him. But as always, I make no apologies for the poor quality of a video. I don't have the equipment necessary to make a quality video, but it's about it's about what's in it. It's about the message I'm trying to get across. And the message is that the court system, in my experience, is rotten to the core. So please feel free to leave any questions you have in the comment section down below, and thank you very much for watching this video.